Well, good morning. We're here for our weekly Board of Commissioners meeting. It's good to be back with you. It is Wednesday, October 16th, 2024. It's 9 a.m. We're here in the Senator hearing room, and as always, we start with the Pledge of Allegiance, if you'll join us. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Well, we're going to slow this train down this morning because we do have a public hearing at 9:30, which we will wait to start that public hearing, but we have a little bit of business in the consent calendar.
Yeah, not much.
So if you want to move the consent calendar.
And no public comment, right?
No, nobody was signed up for public comment. We'll probably have people for the public hearing, though.
All right, Mr. Chair, I move to approve the consent agenda under Public Works. The purchase order with Northside Ford in the amount of $307,585.62 for the purchase of 4 2024 Ford heavy-duty pickup trucks to replace 4 heavy-duty vehicles that are end of life through April 30th, 2025. And approve the commercial on-site septic grant application with RNB Properties in the amount of $125,374 for the construction of commercial septic system repairs and improvements for commercial property located at 110 Lake Street East in Detroit, Oregon, tax lot 105E01CD01300 as part of Marion County's American Rescue Plan Act funded commercial septic repair, alteration, and replacement grant program through October 31st, 2026.
Yay.
And approve the intergovernmental agreement with the University of Oregon in the amount of $240,000 to provide emergency management planning services for the Marion County Underserved and Rural Community Population and Infrastructure Vulnerability Assessment Project through March 14th, 2025. And under Tax Office, approve an order advancing tax levies to certain small taxing districts as referenced in Exhibit A in the amount of $305,834.80 for tax year 2024-25.
I will second the motion. Any further discussion? Where's that Lake Street? What commercial property is that?
This is the RV park, the Lakeside, Lakeview, whatever it is on the north side of the highway.
Okay, all right. I thought maybe it was Detroit Lake Marina, but I know they're putting in a system.
Yeah, this is that little tiny RV park up on the hill.
Good. I think this is the first commercial
It is.
Grant we've
I feel like there should be
approved.
confetti falling from the sky.
Yeah, that's right. I see staff shaking their heads, so that's good. And maybe we'll get a start to roll here, get some more of these done. All right.
I think that your great relationship with DEQ recently is what's going to make things start moving. Well done.
I'm the nice commissioner, that's what you labeled me as.
That is 100%
All right,
true.
okay. If there's any further discussion, hearing none, all those in favor signify by saying aye.
Aye.
Aye, all right. All right, we will stand in recess until 9:30. I'd ask for unanimous consent to allow Commissioner Willis to vote on the consent calendar.
So moved.
Okay, Commissioner Willis, how do you vote?
Aye.
Okay, Commissioner Willis votes aye. Thank you. And then I guess we are at, well, we got 1 minute here, and then I'll wait until it's exactly 9:30, and I'll open a public hearing. There it is, it's 9:30. All right, Chair will open a public hearing to consider an appeal of the hearings officer's decision denying conditional use case number 24-006, Joy Blackman Revocable Trust. All right, staff is here. John, welcome.
Hi.
It's your first time here for public hearing? Or
First
all right,
public hearing for you
good.
guys.
Welcome, congratulations.
Oh, thank you.
Well, let's see.
Yeah.
It'll be fine.
So we had some submissions yesterday. I've got 5 copies for you guys. Give those to you. Thank you. One is from a transportation engineer and the other is from the appellant / original application representative.
John, I'm going to ask you, were you able to review this? Because this just got handed to us.
Yeah.
You want to summarize what you just handed to us? Have you had a chance to review it
Yes.
in your report?
So the first one that came in is from a transportation engineer out of Bend. And he is in support of denial of the application. He basically says that given the topography conditions and geometries of Little Haven Lane South and Viewcrest Road South, site distance deficiencies exist. Further, based on review of Oregon Department of Transportation documented crash history for Viewcrest Road South near the Little Haven Lane South intersection for the most recent 5-year period, it appears there are crashes resulting from excessive speed and insufficient site distance. So he's kind of arguing that the traffic conditions are not suitable to another dwelling on Little Haven Lane.
Okay, thank you.
The other one is
Actually,
from,
may I ask a question?
Oh,
Sure, well, yeah.
Did
I was
our
gonna-
team of engineers that do traffic?
Consists of 5.9 acres of naturally forested hillside in the rural unincorporated area of South Salem. Properties directly surrounding the subject parcel to the north, west, and south are zoned special agriculture. The properties to the east are zoned acreage residential. The adjacent acreage residential parcel tract extends the City of Salem urban growth boundary a half mile to the east. The urban growth boundary is also a half mile to the north of the subject parcel. Some of the special agriculture parcels around the subject parcel have woodlots, and most of those are simultaneously in use for rural residences. Many of the SA zone parcels around the subject parcel are solely in use for rural residences. The Planning Division requested comments from various government agencies. The comments provided can be found in the staff recommendation as well as the case file. The application addressed the criteria of conditional uses in the SA zone, siting and development requirements in the SA zone, and non-farm dwellings in the SA zone, including an analysis of a 2,000-acre study area. Detailed discussion of these criteria can be found in the staff report. Because this appeal is focused on the issue of access, I will not go into detail about the criteria of the non-farm dwelling, but I can answer any questions about those criteria. Staff and the hearings officer determined that the applicants have met the specific conditional use criteria related to approval of a non-farm dwelling. The access to the subject parcel is via an undeveloped easement that utilizes tax lots 2,000, 2,301, and 2,300 in that order. This easement has existed since at least 1971. Tax lot 2,300 was partitioned twice, once in 2005 and again in 2008. Both new parcels had homes developed clustered together at the end of Little Haven Lane South. The dwelling on tax lot 2,301 was developed in the corner of where the easement turns southwest from the edge of tax lot 2,000. Currently, 4 parcels with dwellings are addressed off Little Haven Lane South. but the dwelling on tax lot 2000 has frontage on Viewcrest Road South. Staff has historically not counted dwellings with frontage on a public road towards the maximum of 4 that may be served by a private road, because these parcels could, in theory, take access from the public road. Staff approved the conditional use application without requiring a variance to Marion County Code 17-110-800, dwellings and all other buildings to be accessible to public street. The staff decision was appealed to the hearings officer, and a duly noticed public hearing took place on May 2nd, 2024. The hearings officer issued a decision on July 30th, 2024, and determined that a variance to Marion County Code 17-110-800 would be required for approval of the application, and that therefore the applicant has not met the burden of proof because the private drive would be used to serve the proposed non-farm dwelling and already serves 4 dwellings. Because the parcel with frontage on Viewcrest Road South also could not accommodate another driveway access. The hearings officer decision suggests that staff interpretation of Marion County Code 17-110-800 should be that this line of code, quote, having direct access by abutting upon a public street, end quote, implies an abutment that could actually permit another access. The abutment of tax lot 2000 on Viewcrest Road South is only 60 feet wide and already includes Little Haven Lane South. Marion County Land Development, Engineering, and Permits confirmed that this abutment cannot safely accommodate another access. Based on the hearings officer's decision, this application could be withdrawn and reapplied for simultaneously with the required variance. Therefore, staff recommends denial of the appeal. The board may also wish to provide guidance on how to interpret this section of code moving forward, and I will stand for any questions you may have.
All right, go right ahead, Commissioner.
John, can you explain the easement? What's the importance of the easement?
The importance of the easement is that the section that accesses the proposed non-farm dwelling is undeveloped. So it's lines on the page. It has been utilized at one point by a well truck, but it is little more than a path currently. It would require development to be able to actually access it.
Okay, but how does the existence of an easement impact this application? Can you kind of speak slowly and use small words?
The parcel is landlocked, so it's not abutting a public road. There's no way to access it other than this easement. No, this is the subject parcel, which off the top of my head, I cannot remember the tax lot number.
It's 3,300.
Thank you.
3,300. Okay, thank you.
It's 3,800, tax lot 800.
Sorry, what tax lot is it?
It's tax lot 800, sorry.
Tax lot.
3,300 block with address range, yeah. So yeah, tax lot 800. If you're looking at one of the maps, it is the one farthest to the west, the first special agricultural zone parcel next to the...
Is it the group of the large grassy area and surrounded by the trees?
No, it is entirely tree covered. It's roughly square shaped, just west of the kind of 3 somewhat bean shaped parcels.
Thought I knew what we were talking about, and now I just got totally confused.
John, these maps you handed us,
Somebody submitted them.
somebody just submitted those?
There is a map on Exhibit 2 that shows the easement going to the subject parcel. well as Exhibit 4. But on Exhibit 4, the subject parcel is not very clear. This helps, it's from my notes, but showing.
Oh, it's not even any of these like that we're looking at.
Yeah, sorry. It's-
No. Okay, so the idea is that they would have to drive down this road.
Yes,
And
this
this
is
is
the
through
existing.
the property, the current property owner that purchased this property?
No, this over, this is one of the appellant's properties, tax lot 2,000. This is 2301, and this is 2300. So it crosses
Several
three
properties.
different properties.
Got
That
it.
road's already there.
No, it's an easement.
The existing Little Haven ends right there at these three properties.
Okay.
The easement that has existed goes down it, but it is an undeveloped easement.
Okay.
And there's no other road around here, because it's all treed in.
Yeah, it's all private land, so, I mean, apart from a theoretical easement, when this was initially created, this was looked at, but it's an extremely steep area, so trying to access it from Inland Drive, they decided was impossible. This was
Okay.
back in the 70s.
Okay.
Can you try to-
Yeah.
When was the
I finally
easement,
have it pulled up.
when was that easement established? Do we know?
We first see it on a survey in 1971.
So before 77.
Yeah, before 77.
So is it this piece right here?
Yes, that's it. So it kind of, the easement goes over this part of the property and tucks right behind that house, and comes right there. You can kind of see that white line.
And is that recorded on title
Yeah,
of this property?
yes. And it's shown in the partition plats that created these two parcels from tax lot 2300 there.
Okay. Okay, that's super helpful. Thank you. Thank you for orienting us.
Other questions, Commissioner?
Um,
We can always come back to it.
yeah, why don't you keep going and I'm
All
gonna
right,
get my
Commissioner,
thoughts
any
sorted.
Good.
any questions for John? All right. Legal counsel, we good, moving on?
Yes.
All right. So we'll have the applicants come forward. I guess this would be the opposed to the appeal, no, the appeal. There we go. Who am I looking at right now? Is that Michael?
I'm the attorney for.
Are you Michael?
You'll need to be on the microphone.
Yeah,
before you
okay, great. Then
engage.
I need Michael to come up. Yeah,
Yeah,
thank you.
that's me. And I brought.
And you can introduce yourself for the
This is the
record.
same thing you gave us in paper.
I just did some bigger.
If you need to point to it, I'm going to have you sit down, introduce yourself for the record, and then if you need to point to it while you're talking, we can help you out with that.
Commissioners, before we move forward, if we can just briefly go through to confirm whether there's any conflicts or ex parte site visits. I assume there's none.
What?
No.
No.
Okay,
I didn't even know about where this
Well-
was until you showed me on a map.
So,
just to
thank-
confirm under the loop.
Thank you, Steve. So
Yep.
just for full disclosure, I mean, I've been on, what is it, the road,
Little Haven?
Little Haven, I believe. I think somebody that I know lives up there, but it's been probably 2 or 3 years ago since the last time I drove up there.
Yep.
So not since this case has been filed have I been out there.
Yeah.
Are you asking that question for your own request?
No, just for
Uh,
potential conflict.
I know I was
In
asking
case
the
there's
question, I'm
any
asking where it came
appeals.
from.
Yeah.
Okay.
Yeah.
Well, it's our practice to not engage in any land use thing outside of this boardroom, just to be clear.
Yep.
You guys ready?
Yeah, go ahead,
Okay.
Michael. Introduce yourself, please.
My name is Mike Pleska, an attorney here in Salem. Would you like to give me my address or?
For the record.
Okay, my address for work is 1820 Commercial Street, Southeast, Salem, Oregon 97302. I represent Joy M. Blackman Revocable Living Trust in this matter. And what I'd like to do today is give a little history, kind of to follow up on what John was talking about, to give a little context. And then to talk a little bit about the easement we were talking about before I brought and blew up some of the exhibits that you guys have in front of you, but I just thought it'd be easier to have a bigger picture of that to show. And then talk about the one item that wasn't approved, like John mentioned, the conditional use application we applied for. All of the criteria were approved by both Marion County and the hearing officer, with the exception of Marion County Code 17-110-800, which is a general applicable development criteria. And so I'd like to talk about what I believe the interpretation Marion County did and why that's correct, what the hearing officer, their interpretation was wrong, and then kind of two asks. You have the ability as commissioners to make the approval of our conditional use application, and so that's one of them. And two is to kind of restore the status quo. So in the future, when there's situations like this, Marion County in the past, it's our understanding, has not ever had an interpretation of this code different than what they've always done in the past. And what they did in this case, is my understanding, is been the status quo, and we'd like to restore that for Marion County planning, so they have a clear determination in the future in cases like this that come up, that they can make that ability like they've done in the past. And so that's kind of our two asks that I'd like to go through. So the property, like John described, is 5.97 acres. It's by Sprague High School, just to kind of give it a little more context. And if you take Kubler until it turns into Viewcrest and start heading down Viewcrest towards River Road, and you start getting into the first turns, it's the second turn on the left is where Little Haven is. And so just to kind of give a big picture of where that's at. On the history of the property, my client and her husband bought the property 50 years ago. And the idea when they bought it was for their children to be able to build a house on that property. And that didn't happen. But my client's granddaughter, Ashley Blackman, and her fiance would like to build a house on that property. Just one house, just for themselves and their daughter. And so to do that, because of the zoning, they applied for a conditional use application like John talked about, and that was approved with all respects. And that was done in March. I have an Exhibit 1, which I put into the record you guys have. It's a letter from Ashley Blackman, granddaughter, who, it kind of gives a little history of the property, kind of what her grandpa was looking to do, what they're looking to do. And I think that's important just to give some context. The other exhibit that I have in front of us here right now is Exhibit 2. And like John said, that's a 30-foot easement. John mentioned our property was bought in 1972. This survey was done in 1971. And so I thought it was important to show that the property, one, has access through this easement that's legal access. And it's really the only access we have. Like John said, on inland, it's not really, it's unfeasible for them to be able to get access any other way. So this is the way they need to do that. And when the clients bought the property, there were no other houses on this property. So it's not like they were already using it and were trying to jump onto that. This was back 50-some years ago, and there weren't. So I think
Sorry,
that's
can I interrupt you for a minute?
Sure.
You mentioned 2 dates, 1971 and 1972. Can you just tell me what happened those 2 dates again?
Yeah, in 1972, my client bought the property.
Okay.
So that's 1972. 1971, if you look at this Exhibit 2, which is the survey, which is blown up here, there's a date from the surveyor on that that says 1971. And so the reason I thought that was important, because it establishes the easement was there prior to us even purchasing the property. And so, and that exists still to this day. And so
The survey was performed in 1971?
Yes. it
Okay,
was.
and was it filed with the county at that point, you know?
I can hardly hear.
I don't know if
You
it
don't know?
was.
Okay.
If it, John says it was, so I'm going to say
It
yes.
was,
It's recorded in our survey graphic index, so it was filed with us.
in 1971.
Yeah.
Okay.
And- Okay.
Keep going.
Okay. And so I think that the next exhibit I have is really the general applicable development criteria, which is Marion County Code 17-110-800. And I highlighted a couple things, I think when the county looked at it from a planning perspective, and kind of my next few slides I have. I'll go back and forth for a little bit, but you have these are exhibits 4 and 5, and these are just bigger versions of exactly the exact same exhibits you have, but I just thought it'd be easier to see it
That's fair.
bigger. So, so that one. And looking at, I'm going to switch the other one just to give it a better perspective to show kind of a, you'll see when I show the next slide. And this, I'll get back to blank, but is Viewcrest. And I think that's important from what the planners were looking at, and looking at this statute, and does one of the parcels abut a public road? And that's tax lot 2000 that abuts Viewcrest. And yes, they are, to make it clear, one of the residents is using one of the 4 using Little Haven, so the private easement today. But the planning in this, their determination, which the hearing officer, disagreed with, her interpretation of it. But planning in the past has interpreted situations like this, that where it abuts it, it does not have to count as one of the 4 dwelling units. And that's how they were getting the ability for our client to be able to have the conditional use application approved.
So because tax lot 2000 falls along the line on the north of it,
On-
it's stating that it's not one of the 4 easements, the access
Right
points
there.
on Little.
Right.
That-
Oh my gosh, okay,
So it abuts
okay,
that little piece.
perfect.
It
Thanks
butts
for-
the road.
Thank you.
Abuts, that's Viewcrest.
Right,
Just
yeah,
so.
it touches it.
So their interpretation, and what I'm trying to argue, is that the hearing officer got it wrong. Their interpretation that Marion County has had all the way up until this point has been consistent with what they did for us, for our client. And the hearing officer just disagrees. She, on page 8 of her order, says it doesn't have direct access because it uses the easement to get there. I argue, because it does abut the property, and you could say, well, it could have access. Does it today? No, it's using the easement. But I think, Marion County, the planners got it right. I think the hearing officer got it wrong. You guys have an ability today to restore what I'll call, back to the status quo of what Marion County has done in the past. And like I said, I like to get that restored. And again, the hearing officer decision to be overturned to get our conditional use application approved, so.
Mr. Chair, I have a
Yeah, go ahead, Commissioner Wells.
So I'm reading the code here. It says a private drive shall not serve more than 4 dwelling units unless the parcels on which those units are proposed to be placed were established with the approval of Marion County in accordance with state law and Marion County ordinances prior to May 1st, 1977. Since this lot was surveyed, recorded, and purchased prior to 1977, why didn't you use that part of the code?
I don't believe we had, I may need John's help on this, but the ability to do that before we didn't have a residence established there, so.
I understand that. I'm sorry. I'm just reading this. It says unless the parcels were established. So there's no,
Doesn't
I
require.
don't see any residence language here. I just see unless the parcels were established in accordance with state law and Marion County ordinances prior to May 1st, 1977. So since your parcel was established prior to May 1st, 1977, isn't that an exception to the 4 dwelling unit rule?
That's the way I was.
I believe it could be interpretation, and I mean, I'd have to give deference to John. I mean, we didn't have to argue
Right.
that, so I apologize, I can't answer. I mean,
John, do you have is there a reason why that wouldn't apply in this case?
I think in this case, we just went for the first section of that code because we were generally looking at this abutment.
Because that's the way that you've always interpreted this code, so there was never any analysis of the second part of this, is that right?
That is
It's-
correct.
It's not that we made a decision about that, we just never got to it.
Yeah, because we did not do a variance to it, we didn't sit down and look very hard at that section. We did our usual calculation, which in this case, there is very little that abuts Viewcrest. But because that is a clear way to do the count, we just look and say how many dwellings are there, how many abut the road, subtract those that are abutting a public road.
And then you said, because we didn't do a variance analysis, why would the variance analysis be relevant in this case to that second part of the sentence?
We probably would have looked at that second part and then,
In a variance, if someone
and
applied for a
then, well, and
variance.
then said the variance does not apply.
Why, what do you mean the variance does not apply?
Because the first part applied. It's like an unfortunate equation.
Wait a second.
No, I'm saying I agree with your interpretation of that second part.
Meaning
this-
that you wouldn't have to get a variance according
Yes,
to the second part of the
if we had
sentence.
gotten that far, but we didn't. We said no variance
You
required.
made a decision on the first part, and then everyone started fighting about that first part. Is that kind of it?
Yeah, so we have not really gotten to looking at the variance, even though the basis of the appeals has to do with that section of code.
Okay. Okay.
That's why I asked the question, when was it established? Prior to 1977, and it was 71, because of what you're saying.
Right. So here's sort of my question, John, for you, or you're welcome to phone a friend if you want to.
Phone a friend.
They're not that cool.
I'm not trying to put you on the spot. I'm just
that's
sort of
fine.
curious.
Austin, are you thinking?
So,
We do that often.
So I sort of understand why there's a lot of opinions about this, because the first part says every dwelling shall be situated on a lot having direct access by abutting upon a public street. So you have having direct access, and you have by abutting. And one side says it abuts, the other side says it doesn't have direct access, and so we're fighting over this sentence. But if I get down further,
It says or.
it's just way more straightforward, where it's like, unless the parcels were maybe from 1977. So,
Can you be really clear with what you just said? Because I only heard mumbling.
sorry, so the first part of this, I can see why everybody's fighting, because one side says it doesn't have direct access, the other side says it's abutting a
Right.
public street. And those are both part of one sentence, and so we have to interpret that sentence. But down below, there's this unless. A private drive shall not serve more than 4 dwelling units unless the parcels were established with the approval of Marion County prior to May 1st, 1977. So I look at this and say, the parcel was established before May 1st, 1977, done. There's nothing to fight about, right? Like the black letter law here is super straightforward. There's no 4 dwelling unit restriction on a parcel that was established before May 1st, 1977, and there's no reasonable interpretation of anything other than that. And I realize that there may be some people who don't like that, but I don't see any way to read that second sentence any other way. So I'm wondering, why are we fighting over a potentially ambiguous first sentence if the second sentence gives us the answer to this question?
There is another factor that we kind of didn't get into about the creation of the parcel. There was a partition in 1978, September 12th, 1978, that does appear to have created it, even though it shows up on earlier surveys. It appears that it's one of those situations where it may have been sold by deed and not partitioned or property line adjusted.
But it was recorded with the county in 1971.
The easement was recorded, yes. there's a survey that shows the easement and the subject parcel. And while we don't dig into it, there is also a partition from 1978 saying division of 9.9 acres to 5.97, 2.01 and 2.01 in a residential agriculture area, which is what this parcel was zoned previously.
Okay,
All right.
okay, that's helpful. Thank
So
you.
yeah, and that probably should have been addressed in more detail, but
That's
I didn't
okay.
realize
No,
we were
that's
gonna
super
go that
helpful. That-
direction.
that's-
Yeah, so that goes back to the
That
first
answers my question.
rule
Yeah, got
of taking the 5 minus the 1 that's abating.
Got it,
That's-
got it.
So, because
That's
I was thinking just what you were thinking, if it was established before 77, this is a non-issue.
Well, and I still think potentially it could be
Could-
that way,
could.
because we had a case previously where we ran into a similar thing, where the, I don't know if you remember this, the property, there was a property that the family wanted to put a second dwelling, on-farm dwelling on, and there was some debate about when the second parcel was created, whether, and we had two different recordings at two different times. And so there was this question of, is the second in time recording the relevant recording with the county, or is the first in time recording the relevant recording with the county? And we made a decision that the first in time recording was the relevant recording, and that allowed them to create the second non-farm dwelling. So we have had a situation just like this before, where there are two times that recordings were made with the county, and we decided that the earlier in time recording is the one that was relevant for our decision. So it's possible that we could still do that in this case because they made a recording prior to 1971. That would, and then we wouldn't have to try to interpret this first sentence unless.
And I can kind of look here in a second as we're moving on with other stuff, but the subject, this is from the original staff decision, doing lot legality on the subject parcel. The subject parcel was created in its current formation by partition in the fall of 1978, which legitimized the sale of this parcel and the description thereof, which is included in the deed recorded in January 1978, Real 111, 1041 of Marion County Book of Land Records. Very common in that transition around September of 1977, when we went from you can divide and sell land by deed to having to do a partition, was folks didn't know. And so they would sell land in the old way and then be told, oh, hey, that's not legitimate, you need to come do a partition. So we sometimes have these situations where the deed is recorded before the partition case in land use in 1978. And this was one of those. But it was only addressed in the case as far as legality of the lot, not looking at if it was pre-97. So if those deeds that I found in January had existed prior to that, then yes, it would be.
But I think
created
even,
in
I think the
1977.
question is like, what is the parcel on which those units are supposed to be placed? I mean, I think
Yeah.
it's not unreasonable to say that the parcel was established in 1971 because they submitted a survey of the parcel in 1971, right?
Yeah.
Right.
I think that's a
I see what you're
interpretation we could make, I think.
Yeah.
So Commissioner, if you would, Michael, did you have any more that you wanted to present this time?
I didn't.
Okay.
I mean, the only point of clarification, and I understand what you guys are discussing, is the purchase date, I mean, back to kind of in the same realm, for our client was, I believe, 1972. I mean, that when they originally purchased the property, and to your point, the parcel shows the easement back to 71. I mean, just as one point of clarification. So, other than that, no.
And they, just to clarify, they purchased the 5 point whatever acres, 5.97 acres at that point in
I
time.
believe
In
that.
So-
1972.
In
That's my
1972.
understanding. So,
Right.
Sean, are you shaking your head along with like,
I think what happened was a sale by deed that was not
right?
made legitimate, because the partition in
Well, I just
1970.
I want to clarify something, because I think this is
Yeah.
actually like really important.
Yeah.
Sales by deed in 1972 were legitimate sales. They were legally enforceable sales. So I just want to be
Yeah.
clear, when we're talking about legitimacy,
No,
there's
you're
a
correct, yeah.
one interpretation of legitimacy is this legally enforceable in a court of law in Oregon? and sales by deed in 1972 were absolutely legally enforceable, right?
Definitely.
Separately, I think the fact that a survey was recorded with the county is also legitimate.
Yeah.
So I think when you used that word legitimate, what you meant was the law changed in 1977, and there was a form of recording required in 1977, right? That did not happen in 1972.
It may not have been recorded in 1972. The deed in January 1978 was for this 5.97 acre parcel to Jim Blackman. The partition that happened several months later was between Donald Dagg, who recorded the survey, and Jim Blackman, who was purchasing the 5.97 acres. So the sale may have been in 1972. The paperwork that followed that, we're missing a couple things.
But the survey was filed in 1971.
1971, yes.
Okay.
All right.
Thank you.
Yeah.
So, Michael, if you're good, I'm going to go on to others that are in support of this. I have Sherry Blackman and Ashley Blackman, if you wanted to come up. One at a time or together and share the microphone?
You can
Yeah.
come here. Yeah, there's a second chair there.
Absolutely. It's always easier to do it together.
Especially since we're very nervous.
Well, and I'm going to ask you
And
to...
we're a little teary-eyed too.
Introduce yourself for the record, and make sure the microphone is pulled pretty close so we can pick up your voice. So, as you share the microphone.
Sherry
And
Blackman.
I'm going to say this, you know what? I'm nervous too.
And we're just people.
Real name Cheryl, but I go by Sherry Blackman. And it's my parents that purchased this land. My dad is Jim Blackman.
Okay?
Andrew, go ahead and introduce yourself.
Yes, I'm Ashley Blackman, and Jim and Joy Blackman were my grandparents, or are my grandparents.
You can actually move that microphone, so you don't have to lean over if you want. You can
Yeah,
actually-
move it.
You
You
can
can
pull
pull
the
it
whole
around.
thing. You can pick it
Yeah.
up and it moves.
All right.
So go ahead.
Do we need address?
Extra microphone for them.
Do you need our addresses?
No, not necessarily.
Okay.
Go ahead.
So I guess our thing is, I still miss my dad, so sorry. Going to take a minute here. My dad purchased this land. I was going into high school, Sprague High School. We got that land up on Inland Drive. Don Dagg and John Chalstead, we were buying property all up and around there, around the house that we built, my dad built. And I went to school there first, to Sprague. And so we've been up there for many years. There wasn't hardly any houses up there. Weldon Farms was one of the only ones. And since then, we've watched a lot of development up on Inland Drive and down the slope and all of that stuff. And, but my dad was real close. He was real close to anybody he got involved with, but he bought a lot of land, different land that Don Dagg and John Charlstead owned up there. And in that process, my brother decided he would like to buy a piece of property up there because we're very close family and enjoy each other's company, and it just was a nice area, and we felt warm and fuzzy up there. So that property was purchased in the anticipation that it was all confirmed that the easement was there. Over the years, all of that was always confirmed, and that we would have access to a piece of property that if you don't have that, you don't have a way to getting to it. So helicopter was not the way to get home, and all of that stuff. So the property was always there for a home, and that's what it was purchased for and established for. And I guess my only thing is we're not a confrontational sort of family. We like to be fair. We like to be honest in all our transitions of anything. And it's my thing is, I guess it's just a little frustrating we're to this point disappointing, and our goal is not to interrupt people's lives. Our goal is just to access a piece of property that was purchased from my dad purchased for this purpose of having family close to him. And I am a representative of my mom. She does have dementia. She's pretty good still. She knows all of us and all that, so we still have close ties. But it just, this whole thing just makes it, all those feelings come deep. So I just wanted to address that.
Thank you. Thank you for being here.
Thank you.
Go Olies.
And again,
Unlike other than
Spray.
undergraduate McKay, so.
They wear orange and blue.
All
like
right,
the
all right. I
McKellar.
live in
Orange and
Salem,
yellow.
I'm not, yeah,
Orange
you know,
and yellow.
Orange, brown, and gold. but they
Whatever.
change.
I'm still getting used to this whole Salem thing, all right?
and I'm Ashley, and I guess initiated this whole process about a year ago in order to build a home for my fiance and my 7-year-old daughter, Aubrey. And my grandpa originally bought the property for my dad, and it was a dream of my dad and mom's as I was growing up. It was always this, when we build our house, when we do this and this property, it was the ultimate dream. And my parents divorced and my mom passed away, so that dream never got fulfilled. And you know, I'm in this opportunity now to make it happen. Make something happen that was their dream into my own family's dream and moving forward. And so, you know, I don't just want a house on a piece of property. I want a house on this property because it has value to me. Inland Drive is where I live now. It's the only home I've ever known. We moved around a lot and, you know, went through life, and I've always known that that hill is my home. And I didn't dream that we'd be here today having to kind of fight for it. I thought it would be a lengthy process maybe to convert it, to build on it, but I never would have dreamed we would have had to feel like we're almost fighting just to be able to have access to this land that we've had for 50 years in our family. So anyway, just a little disheartening. Thanks.
Well, thank you for sharing, Commissioner.
Thanks for being here.
Yeah,
Thank you.
thank you very much. Okay, that is the testimony in support that I have. So testimony in opposition, the first person that signed up, Ted, is it Raska? Ted Raska? Good, welcome.
So I'm the individual, we're the party that's.
Could you wait till you get on the microphone?
Yeah,
Thank
absolutely.
you.
Just go ahead and introduce yourself for the record. Sure.
My name's Ted Raska, and my wife Michelle and I currently live at 3238 Little Haven Lane South. And we're the individuals that submitted these 3 color-copied maps.
Okay.
Okay, so as I said, my wife Michelle and I have lived at 3238 Little Haven Lane South in Salem, Oregon since the fall of 2016. And I'm here to discuss some of our concerns regarding the conditional use case CU 24-600. So first off, I'm sorry, we tried to blow these up to make it easier, so I'm just going to point to it. So if I can draw your attention to map A right here. This shows Little Haven Lane, a private road, which is highlighted here in yellow, and where it intersects with Viewcrest, the county public road that's highlighted here in white. And I just want to draw your attention right here where it abuts. There's been reference to small distance that it actually abuts Viewcrest. So that line, that yellow line, is not truly representative of the true width of Little Haven Lane. It's just more there for context. So you can also, right here, notice that the entrance to Little Haven Lane is situated in the middle of an S-curve on Viewcrest and has very limited lines of sight. The red marks that you can see, the little red dot and the red X, they represent the locations of the most recent automobile accidents that we've had right there at that corner. That's caused damage to our mailboxes, damage to street signs, damage to guardrails. And there has actually been multiple accidents every year that we've lived there, which is going on almost 8 years. So if I could draw your attention over to the next map, map B, which looks like this. This is an aerial view of the 4 Little Haven Lane properties. And as we talked, as you can see right here, the solid yellow line, that represents Little Haven Lane, which has an easement allowing for ingress, egress, and utilities. And there's been differing interpretations regarding Marion County Code 17-110-800 and how it applies to Little Haven Lane. But the reality is that, as you can see, Little Haven Lane clearly serves 4 dwellings, with each dwelling having a driveway to directly access Little Haven Lane, as you can see here, 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 and here. And with that being said, we really want to strongly support the hearing officer's interpretation that dwellings must be situated on a lot having direct access, and I want to emphasize the words direct access, to the abutting public street that actually permits access or pre-existing driveway. So, moving down the road a little bit, if I can draw your attention to the dotted yellow line, and what that does is that represents the undeveloped Blackman ingress egress easement. And to simplify going forward, I'm just going to refer to the Blackman undeveloped ingress egress easement as the Blackman easement. So as you can see, the Blackman easement traverses right here. You'll see the words Blackman property. This is the approximate area that has been identified as the dwelling site due to its low hazard rating. And this area has a geohazard rating of 1 to 2. But what I want you guys to consider is the fact that to access that building site, the road, the Blackman easement, would have to cut directly or cuts directly across the hill, with geohazard ratings of primarily 9. That's represented in purple, which is the highest level of hazard that Marion County recognized, and that takes into consideration the excessive slope, the earthquake-induced slope stability, and the water-induced landslide at Little Haven Lane. And with this information that we received, we purchased our home. Now,
Do you
nearly
happen to
8
have a
years-
record of that
We don't.
communication?
We went to the county, it was a phone call, it was such, at that point, a non-issue. There was really, we never felt a need for any documentation. It was a situation, we live on Little Haven Lane. There are currently 4 houses that are being served by Little Haven Lane. We have heard, and we want to confirm that, based on Marion County codes, that a 5th dwelling would not be possible. They verified that there were 4 addresses on Little Haven Lane and confirmed the fact that a 5th dwelling would not be able to be serviced, based on County Code 17-110-800. So now, nearly 8 years later, we find ourselves in this very stressful situation of being concerned for not only our safety, but for the soundness of our investment, all of which could be alleviated by upholding County Code 17-110-800. So I respectfully ask the Board of Commissioners to uphold the hearing officer's ruling and deny the conditional use application case CU 24-600. And I would love to take any questions.
Thank you. Any questions?
Well, I do have a question.
Absolutely.
So when I'm looking at this, the maps you gave us, and I'm looking at the map of the easement, Little Haven Lane, it looks like runs directly on the easement that was recorded in 1971, right? Like it looks like because it's not a county road, it's a private road, right?
Right.
So it's not a county, and so it seems to me that your home and the other homes directly next to you wouldn't have access to this road if it wasn't for the easement that was recorded in 1971. The Little Haven Road wouldn't be allowed to exist unless the property owner, I guess, in tax law 2000 granted that easement to your properties, right? And that easement pre-existed you purchasing your home. And so I guess my question is, if you were aware of this easement, you were aware that the easement was used to give you access, and you were aware of Marion County Code, why didn't you do more research than just, because when I read this, it seems to me, this line that says, unless the parcels were established at approval of Marion County prior to May 1st, 1977, that would have immediately set off alarm bells to me if I was doing my due diligence, because I would have been like, well, if my house has access through this easement, and this easement runs across my property, I gotta know what other parcels existed prior to 1977.
Yeah, I do understand what you're saying. I mean, and I want to qualify the fact that I'm not a land use attorney.
Yeah,
I
sure.
don't work for the Planning and Zoning Commission. I'm an average citizen, right? So when we look at a situation like that, digging into whether or not we should purchase this, we looked at the plain language. We didn't look at potential interpretations of plain language. We looked at plain language. And to us, the plain language was no more than 4 houses could be served by a public or a private driveway, or 4 dwellings. We had 4 addresses. We confirmed with the county planning zone via phone, not with no documentation, and we felt comfortable at that time going forward.
So I just want to clarify, so I'm going to read this sentence. A private drive shall not serve more than 4 dwelling units unless the parcel on which those units are proposed to be placed was established with the approval of Marion County in accordance with state and Marion County ordinances prior to May 1st, 1977.
So-
is that not plain language?
It is plain language, absolutely.
The unless part.
So if memory serves correct, going back in our deed documents that were provided by the title company, I don't know if they referenced the date that the Blackman property was established. So I don't know if I, number one, was provided the information to make that decision at that time.
Okay.
And number two, based on that, I've, communicated the information and how we based our opinion. So to answer your question, we did know that there was an easement on paper, as John had mentioned. And we always were aware that it was there. But again, just to reiterate the facts that we use and the information that we use to make our decision. So,
Thank you.
I mean, I guess in asking that question, do you have any insights on whether or not that information would be provided to us in a standard title search by a title company? Because I don't have the answer to that.
Yeah, I don't know what you would have or wouldn't have gotten. I think the only maybe the question I have is if I were to have been provided this easement document, which it sounds like you were, and I were to see that Little Haven Lane, which I as a property owner would benefit from, was on this easement line, that the road literally ran on the easement line, then I think I would have been really interested in the rest of the easement line, because potentially it could impact me when I purchase that property.
So I understand that. I would ask you to consider the background of the individuals. To me, somebody with your background and your qualifications, that makes perfect sense to me. If you saw that document, you would naturally go directly there. I'm in the medical industry. I'm not in the land industry. I'm not working for the county, right? I'm sure I can bring up a lot of situations where my thought process will go in a certain direction based on my background and my profession, where I would argue that the average citizen that is that is protected by these county codes and stuff, number one, even if they were given that information, and I don't know that we were, I still don't know that they would make that. So my question is, as a private citizen, every time you purchase a home without instilling the resources of a lawyer and spending all of those resources, how are we to feel protected? I feel like we did more due diligence than the average person would have, and we're still in this situation.
You're not wrong. I'm not a lawyer, and I'm also not a planner, just more than an average person probably. And
I'm a hamburger flipper.
the due diligence is difficult for anybody on land use purchases. I think also, though, in this same situation, when you think about the applicant, there's also the same rules that apply to them apply to you. Like there's legal documents that confer this easement exists and that they have a right to access it based on current code.
There's absolutely. And I think one of our concerns is we're not arguing the fact that they have the right to access their property. What our concern is the level of engineering, taking into consideration the geohazard area that this road would traverse to get it to be 30 feet wide, which would be a requirement for safety vehicles and emergency vehicles. would put our property and potentially our safety at risk.
Okay, Mr. Riska, that's not relevant to
I
our
understand it's
decision.
not relevant.
All right, I just want to be really clear.
I understand.
That's
Well,
a
and-
whole nother issue.
Yeah, and Mr. Chair, if I may,
Yeah.
yeah, what I would say is, in this case, we do have to make sort of a decision about the law.
Absolutely.
And
Yeah,
the
that's
facts.
what we're looking at.
And if someone were to build a road, then there'd be a separate process they'd have to go through as far as access goes.
Absolutely.
So- And that'd
Agreed.
be a separate process than the one that we're in.
Yeah, and a
Agreed.
very extensive one.
That response was just in response to the fact and confirming that we always, and we identify the fact that there is an established easement to that property.
Yeah, that's great. No, I really appreciate this dialogue. Thank you.
Yeah,
Thanks
thank
for
you.
your time.
Thank you
Thanks
guys
for
very
being
much for
here.
your time.
Appreciate you being here. All right, Pamela and Joe Verda. Vidra. And welcome. If you would just introduce yourself for the record, please, and make sure that microphone's pulled really close to you when you speak.
Brenda's going to give you a second one, so
Yeah,
you don't have
make
to
it
share.
easier. Welcome.
I'm Pamela Vidra.
And Joe Vidra. We live at 3288 Little Haven Lane.
If you're looking at this, we're number 3. So we are the property that most of the road would go on. And I don't know if the Blackmans have actually tried to walk that road. Nobody's asked us permission to walk down the road. If they have walked down the road, if they haven't, they have no idea how extraordinarily steep that slope is and how we never thought that anyone would ever try to access that road because the slope is so steep. It would cost $500,000 just to build a road. It would be, it's not fiscally responsible to build a house on that lot when the road would cost that much. So we've never worried about anybody actually building a road there because it would take 2 40-foot, what are those called? Huge berms. The berm going up and then the road and then the berm going down. It's just, so my question would be, have any of you walked that road? Have they walked that road? It's dangerous. So, anyway, go ahead. What were you going to say, sweetheart?
I would just bring up the last information that we submitted, and is that in the evaluation at all of your decision and process? The previous records and what was said during...
This?
No.
So we receive an entire application and folder, so we don't know exactly what it is you specifically
Yeah,
have
what are you-
submitted.
what are you
Do you have
referencing?
can you reference it?
Referring to when we spoke the last time, we just reiterate what was said by us previously.
Well, this is a public hearing.
Did you said, I think he submitted something, did you submit something to the hearings officer? Is that what you're
Yes.
referencing? Okay. That's in the folder.
We have this whole folder that we've had a chance to review, but you can highlight whatever you would like to. This is your opportunity to
Call it out.
call it out.
Well, the primary thing of concern is that, as you can see, the original easement, Little Haven Lane, abuts up to the Blackman, and using the terminology Ted Raska brought up, is a dotted line. That this easement has not been accessed for over 10 years, I believe.
We've owned the property almost 11 years, and it's never been used. So, I
Did
don't
you know when you purchased the property the easement existed?
Yes.
Okay.
It's not even wide enough for trucks to go down.
Yeah,
It's barely even a
I just
path.
needed to know if you knew that it was there when you purchased the property.
Yes. Our property, number 3, is the original house for that entire house, all those houses.
The entire 10 acres.
Yeah.
Okay, thank you.
So number 3 had the original easement access road from Viewcrest. So all of the other houses got their ingress, egress off of number 3's, which was the original house.
Okay.
Okay,
Yeah, and as a result of the non-use of that utility easement, we refer to it as utility easement, we recorded a document that indicated that that was only to be used for emergency use only. And we all agreed. The Blackmans weren't involved in it, and we feel that they have abandoned that easement.
They've abandoned that road.
And so
It hasn't been used for anything.
it's a grassy road. As she mentioned, it's not very wide. And as Ted Raska mentioned, to put a road in there would cause, in our unprofessional opinion, but looking at the survey that was done just recently, it would affect the stability of the home because the property would have to be pushed back.
Our house, as you can see, is the closest to the edge of that slope. If they undermine our house and our house starts to slip, are they also willing to have the money for the repair of our house as well as $500,000 to build that road? Have they taken into account all of those issues? And I know they were up here crying, but I mean, I'm crying too. I mean, this is my house that could slide down the hill. So, they have our permission to come on the property and actually walk that road. They need to see how unreasonable it is to think that they can build a road that can have logging trucks, graders, lumber delivery trucks on that road. It's crazy.
So, Mr. Chair, if I may,
Yeah,
I
go
just
ahead,
want to
Commissioner Willis.
kind of make the point again that there's a separate process, a permitting process for these improvements that they would have to go through with the county that's separate from this. And so there would be a process where they would have to get permission from the county in order to do any improvements, even if they have the legal right to do those improvements. Just like with your property, if you want to build a house or something on your property, you still have to get permits from the county to make sure
But
that
if a
you're...
road has been abandoned for that long,
That's a separate legal question when it has to do with the recorded property rights. So just like with your property, if there's a doctrine of law called adverse possession, which is a different doctrine that has to do with transfers of property outside the normal process. It's even different when it comes to easements. So that's actually a specific legal question. I don't know that we can make that decision, or we can make a determination about abandonment of real property rights in this hearing. That's not something that I'm comfortable making a decision on.
Yeah, so just to be clear, we're here to make a decision to interpret the access issue
Only.
And the county code.
only,
Yeah.
not to talk about the geology or the geography or whatever about the road, so.
Not
that's
to diminish that that's important to you.
Right,
We
but-
understand that.
but
But
as-
under our obligation of the role that we perform in this space, we have to be specific to this specific question.
Yeah.
And
So-
then everything that comes after that is after that.
So I want you to know that it's not like we're not hearing you, but we have to stick to the specific facts of this case. That's what's important here for us, to make sure that everybody's rights are upheld.
I would like to ask clarification. Earlier, it was stated that one of the four is using the easement. What was this
Clarify,
referring
what-
to?
My interpretation, not having looked at this in depth, would be that all of the four are using the easement, because Little Haven Lane is a private road, it's not a county road. And if I look at the map of the easement, and I look at the map of Little Haven Lane, it looks like that's exactly where Little Haven Lane ran, was along the easement.
So you're talking about Little Haven Lane
Right, so
as the easement?
Again, I haven't researched this, but if I were to look at this And if there were not an easement across this piece of property, then I would question how any of these houses could have access to Viewcrest.
Okay.
That there must be an easement in order for these three pieces of property to have access to Viewcrest. And then when I look at the actual road that gives access to those pieces of property, and I look at the map of the easement, without having done the research, I say, well, of course they built the road on the easement. Of course they did. So then my interpretation would be these three houses are benefiting from that existing easement that was recorded in 1971.
Yeah, I interpret it as using the quote loosely, the Blackman easement is separate than the Little Haven Lane easement. And that
Is there a separate filed easement?
I can't say.
I don't think so. I think
Yeah, I
there's
don't
only
think so
one
either.
easement filed. Yeah.
That's the point, is that we're reviewing this current filed easement from 1971, which is, for lack of better terms, the Blackman easement, which your properties all are using to access your driveways.
And I'm not even sure that the easement is the issue here. The question is access of accessing that easement and under our code. And that's, well, we can keep going because we have other people
Yeah.
that testify in opposition. Are you good?
I
Anything
believe
else to say?
so. Other than, I just want to restate whether it applies or not, that we, as the four homeowners, we have a restated roadway access and easement agreement that we all agreed to, and that's in the public record, and that this document restricts the use of this Blackman easement as only for emergency use only, that goes behind the homes.
Appreciate that.
We'll come back, John. Yeah, thank you.
Thank you.
Okay, I will call up Mary. Is it upright? Mary, welcome. And just pull that microphone up close and introduce yourself for the record, please.
I'm Mary Judith Upright.
Would you mind putting the microphone down to your
Pull it
mouth
really
so we
close.
can really hear you?
Okay.
There you go.
Commissioner?
My name is Mary Judith Upright, but I go by Judy Upright. Yes. I purchased my property in 1973 at 3197 Little Haven Lane. And I built my house and garage at that in 1978. So we drilled a well and we started the process. The only way to access my house and garage is by driving along Little Haven Lane. I want you to see the map. As a result, my house was the first house served by Little Haven Lane. In 1989, Carol Smith, who purchased her home from Jim and Joy Blackman on Inland Road, wanted to subdivide a neighboring property. My attorney, Norm Webb, had a conversation with the chief planner, Russell Nebon, and this was the first time that I had learned that the code restricted the number of homes that could be served by a private driveway. In 2006, I contacted the county because my neighbors, Alan and Caroline Hart, wanted to subdivide their 6+ acre property to take advantage of the recent acre parcel limits, the change from 5 acres to 2 acres, allowing for the development of 3 new homes. The county told me again that there was a private drive limitation serving no more than 4 homes, and that the Hart proposed 3-lot partition would take all of the available capacity remaining in the private drive. So I knew at that time if they built 2 more homes there, that would be the maximum. In 2008, I offered my daughter and son-in-law a piece of my property from my house to build a home, but the county told us that we could not use the piece of land across from my home because it was less than 2 acres, and that Little Haven Lane already served the maximum allowance of 4 homes. In 2008, I applied and it was approved for Measure 49 to build 2 additional homes on my property. The county told me that I would need to get a variance in order to exceed the 4-home private road. In 2012, my son wanted to explore subdividing my 7.0 acres to build his home to be close to me. Again, the county told him no, because there were already 4 homes being served by the private road. Over the decades, in every conversation that I have had with the county staff, they have explained that my house is included as one of the properties that is served by Little Haven Lane. I have always followed the rules, and I have not been able to provide my family because the county continued to tell me that I could not put in another home because of the private drive limitation serving no more than 4 homes.
Can I ask you, Mr. Chair?
Yeah, go ahead, Commissioner Willis.
So Judy, I really appreciate you being here, and I really appreciate this timeline. This is very helpful. And I also, I would say, I absolutely understand why you might feel like the county's interpretation in this case is changing the rules on you that you've followed your whole life. Here's what I maybe want to suggest is when I was listening to your story, I could understand how the county would tell you what they told you sincerely, because the parcels that you were talking about creating through subdivision were all parcels that are going to be created after 1977, right? So in 2006 or 2008, those parcels are all clearly going to be established after 1977. I think the difference in this instance is we're talking about a parcel that existed prior to 1977, and the code is very clear that there's an opportunity for that to happen, notwithstanding the statement that a private drive shall serve not more than 4 dwelling units, because the next word says unless the parcels on which those units are to be placed were established before 1977. So I think that's how I would look at this. The main difference here is that this parcel we're talking about was established before 1977. If you were to subdivide your property today, the new parcel that you would create would be established after 1977. Does that make sense?
Yeah, I'm quite deaf. I'm sorry.
Oh,
that
I'm
I've got my
sorry.
hearing
He
aids
speaks
turned up
softly.
as much as I can. But because I've been there for 50 years, even though I built my house in 70, I remember buying the parcel from Don Dagan and Mr. Trailstead.
Yeah.
And I remember that this particular land was divided into 3 parcels, approximately 6 acres apiece. And so the one that was down below, Prince Houses had just purchased the property that was now Pam and Joe Vigra's. And they built in 73. And I was then looking and I bought the other parcel that was available up above the 6 acres, close to 6 acres.
Yeah.
And as I recall, the parcel down below, the 6 acres, 5 acres, wasn't purchased. I was going to purchase it. I went to Stuart Compton at Pioneer Trust, and I was going to purchase it. And he said, no, you're a single lady, you can't do that.
Well,
Oh, how
So
times
let
have
me go talk
changed.
to him about that.
He said, Judy,
Those Comptons could get in trouble.
Seriously.
he said, you'd buy everything on that hill, and I said, yes, I would.
Yes, good for you.
But the road, the steepness and the whole terrain, it's going to disturb 3 houses that are there, something, or it's going to just, I just can't imagine. But anyway, that's what I recall. And that Jim Blackman did not, correct me if I'm wrong, Jim Blackman did not purchase that piece until after I tried to buy it, and Stuart said no. But I thought he bought it in '79. My house was all built. I put the transformer, I had the PGE, I did everything to get that, because the original house back there, Pam and Joe's, was just a little Lindell cedar home. It was just a very small little house.
The thing that I keep running into is this is the survey from 1971 that was filed with the county.
Okay.
Okay? And this is the easement, this is Little Haven Road that goes across your land.
It was
And-
yeah.
And it goes all the way down
Yeah.
to this parcel that we're talking about right now.
Yes.
So I look at this and say, this parcel was surveyed and submitted to the county in 1971.
Yes.
And everyone who bought property after that, and there's a lot of transactions, they knew this. This was public record. They knew
Right.
that this easement existed, and they knew that this easement served this parcel.
Okay.
They had notice of that. So
Yeah,
that's
it
where,
hadn't been sold, but it was developed in
right.
'71. No, that sounds right to me.
and so that's where I can see how you would say, wait a second, why can they have access, but my son couldn't have access to my property? And my answer would be because the code says that if the parcel was in existence before 1977, then there's an exception to the 4-dwelling rule. Does that make sense?
There's an exception to,
Yep, there's an exception, based on the code, because this is what the code says. A private drive shall not serve more than 4 dwelling units unless the parcels on which those units are proposed to be placed were established prior to May 1st, 1977.
okay,
Does that make sense?
yeah, okay.
Now, I'm not sure that's the right interpretation. I'm going to ask these folks,
Yeah.
but that's how this reads to me.
That's how it reads.
And Judy, I want to thank you for being here and make a couple of comments. The reason we're here, I'm not going to answer for the county and what they told you back in 2006 or 8, because none of us were here. But the reason we're here is because sometimes you go to our planning department and you get a no. Well, that's why we're here today.
Yeah.
Right? I mean, they got a yes, and then there was an appeal, and it's to us. And this is part of the process that the citizens of Marion County get to go through if they so choose to go through it. And in the future, if you get a no, you might want to dig a little deeper, and there's people in this audience that can help you on those types of things
You don't have to
too.
just take staff's word for a no.
Right.
You can always appeal to the Board of Commissioners.
Not that we don't have great staff, but
Right.
sometimes it can go a different direction. Yeah.
Right.
And often we have land use hearings.
Right. Well, I appreciate your listening. and-
Yeah.
and
Thank you so
and
much.
Thank you.
And hey, good job on buying your own land. And next time, tell them, they don't get to tell you what you can do.
Those Comptons.
I know those Comptons.
Thank you for being so kind.
Thanks for being here.
Thank you. All right. Next, we have Isabel Jocelyn.
Oh, good.
Okay.
Whoops, sorry.
Hello, my name is Isabel Joslem. I am a longtime friend and assistant to Judy Upright. Judy is 87 years old and lives by herself on her 7.08-acre property. Early in 2024, Judy asked me to help her find options for her grandson, Max, to be close to her to help her. I suggested talking to the county to see if she could subdivide her property under Measure 49 or put in a temporary home under a hardship dwelling process. Judy wanted to pursue the subdivision first. On January 22nd, 2024, I called the planning department and asked about the process to subdivide the property. The county staff looked at her property record and noted that she could apply to subdivide her property under Measure 49, since she had that approved. County staff indicated that the parcels needed to be a minimum of 2 acres. On January 23rd, the next day, I called the county back and asked if we could get an exception to the 2-acre requirement, since her property has the Little Haven Lane Road cutting through her property. As part of, and Little Haven Lane is part of her property. County staff indicated that no, the parcels needed to be 2 acres, and she could not subdivide her property she could subdivide her property into 2 parcels. The process was going to take some time to get it approved. On February 5th, 2024, I called the county twice. On my first call, I left a message and requested a callback. County staff called me back. I requested an application to start the process to subdivide the property and ask for information on the hardship dwelling. They were going to send me the application via email, and they showed me where to find information about the hardship dwelling online. On March 27, 2024, I called the county to check if they had sent the application. They told me that the application was online. I also asked if we could apply for the hardship dwelling at the same time as the subdivision, since the subdivision process was going to take too long. They told me yes, she could apply for a hardship dwelling while she was working on the subdivision. They again reviewed the property records and found that there were already 4 homes being served by the private road. County staff told me that although Judy could subdivide the property, a new home could not be built because there were already 4 homes being served by Little Haven Lane Road. They apologized for not letting me know this earlier. They also explained that as part of the hardship dwelling application, the neighbors were going to be notified, but because it was due to medical, they could not object. After this information, Judy decided not to pursue either. This summary shows that it is the staff's determination to allow the Blackman development in violation of the 4 limit that represents a departure from the long-established interpretation. So several times, this adjusts, and I have records of the calls because I call out of my cellular. Thanks, cellulars, you have time and everything else. And every time we call, and I talked to several different people at the county, at the planning department. All of them told me, you can't, because there's already 4. And I went in person, and I didn't put it in my testimony, but I went into the office in person once, and they look at the record, and they printed the maps for me, and they say, you see these 4 homes, this is it, you cannot do it. And I said, okay. I did not get anything in writing. I should have, next time I will. But it's just every single decision Judy has made has been based on the expert knowledge of the county staff, which we look up to guide us on the right direction. So.
Thank you.
Thank you very much, Isabel. Appreciate it. Okay, and next, I had one, I think I got everybody there. One more person, Carrie Richter. Welcome, Carrie. You probably know the drill.
Thank you.
Yeah.
My name is Carrie Richter. I'm a land use attorney at the law firm Bateman Seidel. I'm here today representing Mary Judy Upright. We filed an appeal before the hearings officer, and we submitted testimony. I hope that you've had an opportunity to review all of the record that was presented before the hearings officer, because it is extensive. I didn't see that it was attached to the agenda packet, but I see you have it in your hand, but I think my question is, did you read it?
It's all distributed to us.
You've read it. What you have before you is a conditional use permit to build a non-farm dwelling as a land use permit. ORS 215-4164A requires that you review this request limited to the standards and criteria set forth in the adopted zoning ordinance. I think that's what you've already said, is that you're sitting here as a judge evaluating a particular legal question, which is, what is the meaning of Marion County Code 17-110-800, right? You can't be taking into account all the rest of the noise about geologic hazards or what you knew when you bought. I also want to tell you that easements, the rights of easement holders to use land, is completely, again, separate and distinct from land use. Whether or not this road can physically be built, whether or not these people have rights to this easement, whether or not this easement has been abandoned, all of those questions are noise for the quasi-judicial function that you all are charged with today, which is interpreting and applying a particular code criteria. So that's it. And the applicant has suggested that this appeal is important because it will change the status quo and how staff gives advice. And you've heard both sides of that. You've heard statements that staff says that it's fine, that it will be okay for the Blackmans to have a fifth access. And then my clients have explained that staff has said something else. Again, that is not the criteria you were charged with applying here. The question is not being fair based on what advice, right or wrong, was given by staff, right? This question is a question of interpretation. If this case gets appealed to the Land Use Board of Appeals, the question that the Land Use Board of Appeals will ask is whether or not the county's interpretation is plausible given the plain language of the standard itself. That's it. And so I would point you to, you can have access under this standard if you have direct access by abutting upon a public street. It is correct that Tax Lot 2000 does abut a public street, but it does not have direct access. The only access it can get is by using the private driveway. It cannot get direct access by abutting upon the public street. It cannot, there isn't room. And Ms. Upright testified that she has taken access to her house from Viewcrest for as long as her house has been there. She accesses her driveway that way. There is no other way to get to Ms. Upright's house than through the easement. This is not simply an academic, theoretic exercise focused on where property lines abut right-of-way. This is a question. The county has made a decision that more than 4 houses on a private drive would create potentially safety concerns, would present potential hazard concerns. If the county is going to exempt historic access points, the potential is that you could have many houses taking access on a private road and creating a safety hazard. And that's what we're trying to avoid. The only expert traffic analysis you have in the record indicates that Viewcrest Drive does not have adequate vision clearance. I'm going to quote you to another Marion County Code section. 17-110-770 requires that all driveways maintain a minimum vision clearance area. For driveways, this is a minimum of a 10-foot leg along the driveway and a 50-foot leg along the street. If you're going to interpret this standard to find that Ms. Upright has direct access by abutting upon a public street, you also have to consider whether or not that access will have adequate vision clearance. And I would suggest to you that the evidence in the record shows that it does not. This is not about a theoretical exists only on paper standard. There is nothing in the language of the standard that suggests as much. Finally, I want to talk quickly about the additional clause that Commissioner Willis has brought up. The additional clause says, unless the parcels on which the units are proposed to be placed were established with the approval of Marion County in accordance with state law and Marion County ordinances. There is, as far as I know, no evidence in the record to determine when the unit, the parcel, was created. You've talked about a 1971 survey. I haven't seen a 1971 survey in the record. I have the best and only evidence of this that I can tell is what John read in the staff report, which says, "The subject parcel was created in its current formation by partition in the fall of 1978. Current formation is what creates a parcel. A parcel exists by its formation and the bounds that it is described in a recorded deed, assuming that that deed was recorded before the time that the county reviewed partition plats, which legitimized the sale and in January 1978, and it quotes the book of land records. If the board is inclined to go in this direction and consider this new issue that has never been brought up by the applicants before and is sort of a new issue, I would urge the board to delay its decision-making and so that there can be evidence put in the record to show, to establish when the parcel was created. Finally, I want to talk a little bit about fairness. I appreciate that the Blackman property has had this easement on it for a long time. It was clearly intended to provide road access. What took up all the capacity for this road, for this private drive, was the subdivision of the lots that are now owned by those who also testified in opposition, the Vidras, the Raskas. Those lots, the partitioning there, created this problem. The Blackmans probably got notice of that partition, just like the Uprights got notice of this land use application, and their opportunity to raise concerns over limitations in the land use laws over that impact was in 2006 when that partition occurred. So when it comes to land use, everybody's got to stay on it. Everybody's got to know when the laws are changing and when people are doing things. And so that was the point when the available capacity in Little Haven Lane got taken up. The final point I want to make is that it is not true that the Blackmans' only opportunity to develop a home on their property is if you overturn the hearings officer's decision. The Blackmans can get a variance, which is a separate process provided for in code that allows them to use Little Haven Lane if they can show that it is safe to do so. The testimony you have before you is that it is not safe to add another dwelling unit worth of cars. But the applicant can go and get expert testimony. Perhaps the site distance can be improved. Perhaps there can be changes made. We don't know. But there is an avenue for the Blackmans to obtain the development that they seek. I appreciate your time. I'd be happy to answer any questions, but I urge you to leave the record open if you are inclined to pursue this second clause part of this interpretation before you. Thank you.
Thank you. Questions? Questions?
Nope.
Okay, good. John, hang tight. I'm going to just recess this public hearing just for a minute so we can take a quick little break. I need to take a little break.
Appreciate
Right?
that.
And we'll be back. For the public hearing. John, where'd he go?
He stepped out, he'll be back in a second.
Oh,
He's also out.
well,
It was a long hearing.
it was, yeah. All right, so I have a couple questions for him.
Okay, fine. Nope, not yet.
Now you can stand up.
Did you bring some for all of us? Oh, all right, well, we're waiting for you. I wasn't taking a 15-minute
It's been
break.
a long morning. I'm
All
ready
right.
for lunch too, John.
Yeah, it's good. All right. John, where was my big question? Do we know how wide the easement is at the base at Viewcrest? Is it 60 feet?
I do
20
not
feet?
believe it's 60 feet. Let me look at the map. You know, there's,
Really
That-
doesn't matter. It's not an issue. I mean, it's not an issue that I'm considering. I was just curious.
I see what you're saying, though.
Yeah. And then, I just want to clarify a couple things that still don't, that aren't factoring into my decision, but I heard a comment, I think it was Mr. Vidra, that there was a road agreement between the four owners, and then referencing the Blackman easement was for emergency purposes only. Is that something that has been filed or is on the record?
It would be a private agreement between those.
Right. Yeah, I
but
know, because I used to
we're
live
not
on
aware
a
of
private
that.
road, and the mortgage company wanted to see a road agreement, et cetera. So,
Yeah.
so basically, anything that they did between the four of them would be just between the four of them, and so I don't want to get into that right now, but that's a whole nother.
And it
issue.
does look, based on the tax assessor records, the easement is 30 feet wide. The abutment is 65. I called it 60 earlier, but it appears it's 65 for what
Okay.
that's worth.
Okay, on that, all right. Okay. Any questions for John, or do you want to go into deliberation?
Well,
Or what do you think? What?
They get a chance for rebuttal.
Oh, sure. I forgot. Yeah, it says that right here.
On our cheat sheet.
Yeah.
Mr. Chair, if I
Yeah.
have a question.
You're good?
I'm good.
Okay.
John, do you think that this is a valid interpretation that you're comfortable with? That this this parcel could be exempt from this four dwelling unit restriction based on when the survey was filed?
I think we'd be comfortable with it if it's your interpretation. There is, as Ms. Richter pointed out, there is the possibility of doing further deed research. I did not seek past 1978 because it matched that partition. I didn't really dig into that. 71 survey and deeds prior to 74 are difficult to track down because we can't search them in a database. They're in Laserfiche. We're using the old records. But there may be something in there that would illuminate if, that survey was translated into actual descriptions somewhere recorded.
Did you say illuminate or eliminate?
Illuminate.
Okay,
Yeah.
just for clarity.
Yeah.
So-
I guess either or, though. Yeah.
And I'm going to look at John and legal counsel here. I'm interpreting this question that I'm answering, that we're answering today, is the fact that it was made based on the access was abutted to the decision that originally was made by our planning department was made that there is access, there's property that abuts to Viewcrest, thus we could subtract that property as one of the four and add a fourth property. That's the decision that I believe was made originally, correct?
Yes.
Okay, so, I mean, the evidence to me shows that that is true, right? There's a piece of property that abuts Viewcrest, And if in the past, we've made decisions in our planning department that would say, hey, this can be subtracted so we can go to a fifth property, I'm okay upholding that particular decision today. Your question is a whole nother, I'm with you on that too. Could it be pursued as it was, this property was filed before 1977, which was Measure 49 deadline. Could this property be brought in as a result of that? I'm okay with that, but I don't think that that is the question before us today. But clarify me, please.
Well, I think we have the ability to make a decision. So the evidence that I received in this hearing was that this survey was done and filed with the county prior to 1977. So based on my plain reading of our ordinance, that seems to me to be evidence that we, as a body, can rely on to determine that more than 4 dwellings can use this road. That's the way that I think we can make the decision. We don't have to make the decision based on that evidence, but I heard evidence that I'm comfortable relying on based on my plain reading of this code, that a private drive could serve more than 4 dwelling units. So I think we can make a decision that way if we want, yes?
I believe you guys can make a decision, but there's a message passed along from the director that property can only be created by plat or deed. A survey cannot create a property. So if there are deed descriptions that resulted from the survey,
yeah,
that would create the property.
And that's where that's where the further research would have to be done, is that right?
Exactly.
Okay.
Because it does appear the property that was sold to Miss Upright was sold in 76. There appears to be a situation lining up where Donald Degg and Tresselstead were splitting this property up to sell it to different folks. Because of the time period and not needing to do a partition until 77, there are some details that we're missing. And it appears the plan came together in 71. That 5.97 acres is shown on there. But we don't know where the original deed is that describes that parcel prior to 77. If that makes sense.
Well, I think, so,
Well, just to be clear, the deed is somewhere, in some record.
One would hope.
Thank you. My microphone wasn't on. So well, there's lots of places that it could be stored, some room, right?
Yeah.
A microfiche. I guess for me, just because you guys have done a lot of deliberating and I've been reading this extensively, I don't want to make a decision that's going to cost a whole lot of money to get appealed to LUBA. I think that I want to know where that deed is and I want to know what it says.
Yeah.
I think that's the most, I mean, I know this is costing everybody money, but it costs a lot more money to go to LUBA. And everything else that was said on the emotional space and the geological things, which to me aren't relevant here, right. I want to know what that deed says.
Yeah.
And
we can hold the record open. Can't we?
Okay.
Can't we hold the record open and come back?
Yes.
In a week or two?
Yeah.
Okay. That'd be.
I would like to hold the record open until planning can tell us when they need to come back. And I know that there's a window of time that you have to decide on. So what does that look like for the appeal timeline?
I believe based on the last extension from the applicant, we are good on a decision from you until at least the end of December.
Okay.
So we are in the clear. I do want to say we might not find a deed.
I understand.
I want to be clear that,
But because you
we
didn't
think
look
that
for it,
potentially-
and I understand why you didn't, I would
Yeah.
like for you to look for it. Austin is now coming forward, Mr. Chair.
So
12:10
Thank
is how
you.
it's going. Thank you.
Okay, I'm fine, the chair's fine having a motion to leave the public record open and set a date that we would come back. I'm also fine, and I appreciate your comments, Commissioner Bethel, about not wanting to cost a lot of money. If we can come back with that, fixing that issue, as to pre-1977 or not. We can move forward with certainty with that.
That's
I
right.
think that's what you're saying. I'm also fine the other way, but I will take, are you good with her?
I'm okay with
Okay.
that, yeah.
So I will take a motion, and I don't know how much time do you think we need before you can get the information?
I think about 2 weeks, but if I may, can I address what you had said a moment ago, Kevin, about
Yeah.
the initial interpretation? Because I know at least one of the conversations with Isabel was with me, and I explained that fully enacting the Measure 49 to create 2 parcels on that property, which could be done even without the Measure 49 because of its size, would require a variance because it would be adding 2 additional parcels, not just 1. It is likely that at some point that is going to come up, whether under its current ownership or in the future. And this interpretation will come back, this interpretation of how planning views that section of code. And so I think we are also just curious about if the commission prefers the hearings officer's way of interpreting it versus staff's previous interpretation.
Well, maybe,
Is that something that we need to answer today on this specific?
No,
that
not
I would like to
necessarily.
I don't want to get to, I need to spend time with probably the planning director and legal counsel to explore that further. That's not research I have done coming into this today, and I don't feel comfortable going down that rabbit hole.
Totally fair. I just
Thank
wanted
you.
to bring that up because we're kind of going in a different direction with the 1977, but many of these, because we do deal with this on a regular basis,
Right.
the 77 thing doesn't even come up.
well, part of the reason why, at least in this case, I'm interested in the 77 thing, it has to do with notice. So some of what I'm trying to do is I'm trying to be fair here. Like, I recognize that it potentially could be a burden on the existing owners of the dwellings here for somebody else to have a legal right to put a road across their property. I'm very well aware of that, and I realize that's a burden. The notice issue matters to me. So if when you bought your property, you had noticed that this easement existed and that this parcel existed, which based on the record before me, I kind of think you did, then I think the fairest thing to do is to allow everybody to use their property rights, both those people who have dwellings here, who use their property rights to access Little Haven Road, and also the property owners who have a property right to access their property using the same easement. I think in my mind, that's the fairest way to do this. The most straightforward interpretation in my mind to get to that outcome is through the second sentence,
Yeah.
right?
Right,
But,
we got to see it.
but it's possible that you come back and we have to make a decision not based on the second sentence, and we still have to try to make the best decision we can on the facts in front of us, so.
Definitely. Thank you, Commissioner.
Okay, so does November 6th work? I'm looking at Brenda too. I think we have a board session. That gives you almost 3 weeks, right?
Yeah, that should
Okay.
be more than enough time.
And I don't see something piled up on our schedule behind that. So, so I would take a motion to leave the public, to continue the public hearing on date certain, November 6th, and to leave the record open. Would that work?
So if you're continuing the public hearing, then everyone will have a chance to come back and present testimony again. If you just want to leave the record open only for documents, you can also do that. It's up to you.
Yeah, what would you prefer?
Well, I think we've heard a lot of testimony.
Yep.
I don't want to prevent people from testifying again, but I think both sides have the opportunity to submit relevant documents to this question. I think everybody here sort of understands what the question is that we're asking, so
Okay.
that's my sense. My sense is the
Okay,
documents.
so we would, the motion would be to close the public hearing, but leave the record open for a decision to be made, so it's not a public hearing on November 6th.
Right. Yeah, so you would.
So I'll make a motion to close the public hearing, but leave the record open.
Yeah, leave the record open for a date certain,
Until
or
November
Till
it needs to be
November.
at least 7 days. You could do 14 days, and then there's an opportunity for rebuttal of 7 days after the record closes, so build in that rebuttal of 7 days.
So we would close the record on the week before that, right? The 30th?
Sure.
October 30th, so that's 2 weeks.
Yeah, so you could do 2 weeks and then a 7-day rebuttal, and then you would come back and make the final decision.
So what if the motion, I'll just make the motion to close the public hearing and leave the record open until October 30th.
I second the motion.
We have a motion and a second to close the public hearing and to leave the record open until October 30th. Any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Aye. All right. So I will close the public hearing and the record will be open until October 30th, and then we will come back the next week, hopefully.
Thank you,
Thank you, everybody,
being
for
here.
being here today.
Do you want to go back into board session and adjourn?
Do we have to? All right, I'll reopen the board session. Do you want to say anything before we
Nope.
adjourn?
No, I need to use the restroom if I like so much.
It's been a long day. Why am I getting commercials showing up on my, all right. We're gonna close the board session.
We are adjourned.
Why is my computer going off?